Welcome all to Juris North and one discussion. Today we are going to have two experts from Brazil. Before we start, again, the idea is to have one main expert on a particular topic. We agreed this a few months ago. And all the rest of the attendees are going to be able to ask any questions we want. We follow a sort of Rolfian methodology. We have the experts, and the rest of us, regardless of whether we are professors or students, we are all the same. We are people interested in learning from each other, and regardless of our disciplines. We may have philosophers, lawyers, political scientists, or any people at large. The idea is to learn from each other. Today, obrigado to my two colleagues from Brazil, Dr. Rubens Becak from Universidade de Sao Paulo, Brazil, and Dr. Jairo Lima, University of Northern Parana. Obrigado for joining us. And they will be talking about the Unwritten Brazilian Constitution, human rights in the Supremo Tribunal Federal. For all the others who are listening and are watching our presentation today, this is a book launch, a book presentation. Rubens and Jairo are both scholars in Brazil. Rubens right now is doing research in Salamanca, Spain, and they are presenting a book. Both of them are editors of. Once again, I think Rubens will start the presentation.
Yes, Jairo. Yes.
So without anything else from me, Dr. Rubens Becak, your floor.
Okay, thank you very much, Professor Jorge. It was a pleasure to meet you, not personally, but almost in pandemic situation. But it's a pleasure for us, I may say for me and Jairo, to be with you, Juris North, and your invitation. For me, it's a pleasure to see all your team, I mean, from Europe, European countries, Latin American ones, and it's a pleasure. Jairo and me decided to divide the presentation or do a short introduction telling you about the political situation 30 to 32 years ago and expectations and the constitution itself. And then Jairo, with I saw his slides, his films, he will make a PowerPoint presentation as he told me. So talk about the Brazilian Constitution of '88. We have to get in the short talk about the historical moment and the expectations of the '87-'88 National Constituent Assembly. It was a moment, I would say, very special whenever the transition of power from the military rule to the civil one has reached a milestone that considered that without a national pact, I would say a national pact, we couldn't proceed. It is to say that everyone considered impossible make a real transition with institutions based on the one's constitutions. The one from '67 and the entire amendment made in '69. People say we had two constitutions. In fact, we had a constitution of '67 and the so-called amendment number 1 that changed 80% of the former constitution in '67. The country was in a great expectation that the forces involved in the scenario could make a new pact and a brand new one that could act as a route to get democratic institutions flourishing. In fact, what happened was that all the caged expectations, needs, and pressures attended in the National Assembly, making it a very documented point where everything congregate to get a pretension. Such groups, I would say, identity ones, Indians, lawyers, church, Catholic, and others, environment, agribusiness, banks and corporations, education staff, and several others flowered to Brasilia, our capital, to make their lobbies. I would say legitimate lobbies but very, very assertive. We could see the ambience hence as a melting pot, wherever everything and everyone has a pretension to be filled up. It is to say, the Constitution would be a repository of everything in need to be legitimated, as were blocked and denied in the past, especially, not only, but especially during dictatorship. Dictatorship, as you know, lasted from 64. We have several means of to the time, but they would say 64 to 85 when we have the civilian transition. What emerged in the constitutional text, a huge one, the one of the biggest worldwide constitutions history. The document was called the Citizenship Constitution, in the saying of a very well-known politician and president of the convention, Ulisses Guimarães. It was a document full of everything in it, but this is important to highlight. Novelties very important to Brazil, which gave influx to the same condition in other Latin American countries in their own processes. I would mention, not to detail here, Colombian process, Bolivian one, Peruvian one, Ecuadorian one, for instance. I'm meaning of the great catalog of human rights in the whole specificity of it. It is to say, it contains a whole list of civil and political rights, social ones included in it, economic, social, educational, and labor ones, and also cultural ones. It was a great change, and I should say a breakthrough with the previous traditions. Everything was listed in the Constitution as mandatory. Another point is that the Constitution incorporated all dispositions concerning human rights that appear in the international conventions and treaties signed by Brazil as human rights, with the same treaties signed by Brazil as human rights, with the same protection as the other ones. This disposition was better assigned in the reform called Judicial Reform from 2004. Moreover, several of these rights, health, education, security, welfare, for instance, should be taken besides extensively and also universally. It means they are granted for everyone by the state. Brazil, just to remember, is a federal state with 3 levels: the union, states, and municipalities, besides the federal district. Soon, as obvious, emerged a problem that you can guess: how to apply everything taken for granted without solid condition. I mean, public policies and budget, to make it real. How to do it? Here, the judicial review played as a possibility in getting the constitutional provisions done. And the Constitution, new rules for it made room for change. I mean that in the 88, the legislature transformed the former judicial review in something furthermore assertive, as to say, besides the traditional American one, the Marshallian one, that appeared from the first time in the 1891 Constitution, the very first of the Republic, they widened open the European judicial review between us and Brazil since 1965. So from 88 on, the Constitution was signed from 88, the possibility of the use of any of the judicial review systems, depending on the circumstances, deepened the role of the superior tribunals particularly the Brazilian Supreme Court, as we call it in Brazil, the Supremo Tribunal Federal, STF. It paved the way for multiple leading cases that discussed rights, their amplitude, extension, and very, very important to say, an interpretation that in several cases was very different from the literally sole reading of them in the text. In our dictate, we have nowadays, besides the original constitution, an unwritten one, which inspired Jairo and I to organize the edition in debate. Thank you very much. I'll return if in need. Jairo, please. Thank you.
Let me share with you the PPT. So here we are. So good morning and good afternoon for all, or good evening. As said before, I'm Jairo from Brazil, and with Professor Rubens Becak, we have added this book, The Unwritten Brazilian Constitution. So it's a pleasure being here. First of all, it's a pleasure to meet you. And after the presentation, we are open to the discussion, to questions, whatever you want. So first, to avoid any confusion on the Constitution in Brazil, in our book we said the Unwritten Brazilian Constitution. So first, in Brazil, we have a codified constitution, one single text with superior hierarchy of the ordinary law, and this is our constitution. When we say the unwritten constitution, we are trying to emphasize the role of the Supreme Court in the interpretation of the constitution of Brazil. So the unwritten constitution are the cases decided by the Supreme Court that are part of our understanding of the constitution, even though it's not written in the text. Okay, so this is why we say the unwritten Brazilian Constitution. So and as said before, Supremo Tribunal Federal is our Supreme Court, and I will say a little bit more about the institutional arrangement, the institutional design of our Supreme Court in Brazil. So this is the picture of our Supreme Court in Brazil. It's placed in Brasilia, our capital, and the Supremo, the STF in Brazil is the Supreme Court of the country, and it is composed by 11 justices appointed by the president and confirmed by the Senate as the US model. Okay, so in our book, we invited many Brazilian scholars to offer an explanation and investigation on the main human rights cases at the Supremo Tribunal Federal. In these 32 years of Constitution, the Supremo Tribunal Federal in Brazil has played a super important role in the interpretation of the Constitution. So I listed here the cases we presented in our book, which are freedom of speech, right to abortion, embryonic stem cells research, racial quotas, gay marriage, criminalization of homophobia, political party loyalty, corporate campaign donations, homeschooling, high-cost medicines, presumption of innocence, and unconstitutional state of affairs. These cases, we have chosen them because they are the most important of these 32 years. This does not exclude the fact that there are many other important cases in our jurisprudence. So this is the first 12 main cases in our constitutional rulings. Okay, so now I'm going to briefly explain the result of these cases, how the Brazilian Supreme Court has decided each one of these cases. And these rulings of the Supreme Court, they represent a partial understanding of our Constitution. We have so the written Constitution and these rulings that compose what we know in Brazil as constitutional law. Okay, so just to add an information, in Brazil, our juridical tradition is based on it's not based on common law. Okay, so we are a stated law country. So what did the court say in each one of these cases? The first case is related to freedom of speech. It's a super important case in Brazil, decided in the beginning of the 2000 years. So in this case, the Brazilian Supreme Court decided that the publication of books spreading anti-Jewish ideas is not a constitutional use of freedom of speech. So the Brazilian Supreme Court banned, prohibited the use of freedom of speech to publish anti-Jewish books. The second case is related to the right to abortion. In Brazil, we just have two possibilities of legal abortion. The first one is related to when the woman is raped, and the second case is when the pregnancy is causing a very important risk of death for the woman. This is the both authorized cases. And in this decision, the Supreme Court included one more case for the right to abortion, which is the case when the pregnancy is related to an encephalous fetus. Some years ago, this case was super discussed because of the Zika virus, for example, which was causing an encephalous fetus. So the Brazilian Supreme Court allowed the use of abortions for the woman when they are expecting an encephalous fetus. So now we have these three possibilities for abortion, which are still super restricted in our constitutional law. The third case is related to genetics as well. It was a debate around the beginning of life. When is the beginning of life in the Brazilian constitutional law? This was a discussion related to embryonic stem cells research. And the Brazilian Constitutional Supreme Court decided that the extraction of stem cells, non-viable human embryos created in assisted reproductions is allowed for scientific researches. So there is this allowance in terms of scientific research to use this embryonic stem cell. So they are not killing lives as the religious field was trying to say, that this kind of research is a research that that's causing death. That's not the case for the Supreme Court. The next case, is a super a transnational case because many countries face this problem related to racial quotas, mainly in Brazil, where we had a long period of slavery, more than 300 years of slavery. We have been accepting, and we have been included many people from Africa, and this is part of our country. We are a mixed country, a country with many different ethnics, and the racial quotas is a problem related to mainly to public universities. So the Brazilian Supreme Court ruled in favor of the constitutionality of racial quotas at public universities in Brazil. The next case is related to gender issues, as we can say. In 2011, the Brazilian Supreme Court ruled on the possibility of civil unions between gay people, between man and man, human and human. Okay, so the court said that the protection for the family in the Brazilian Constitution encompasses the protections for unions between people from the same sex. And strictly related to this gender issue, there is another very recent case called Criminalization of Homophobia. In Brazil, as you may know, there is a high number of violence against gay people, against transgender people, and this is a huge problem in terms of freedom of speech, in terms of public policies. So there was an issue or on a case before the court, before the Supreme Court in Brazil, trying to say that the parliament in Brazil is under omission in criminalizing the hate speech against homosexual and transgender people, because our anti-discriminatory law doesn't include rape speech against gender issues. So the Brazilian Supreme Court decided that there is an unconstitutional omission by the Brazilian parliament in criminalizing homophobia. So, considering this omission, until we have a specific law to protect this omission, it's allowed to use the actual anti-discriminatory law for the cases against homophobia. So this case was super debatable because in fact, the Brazilian Supreme Court was creating a criminal law, the Supreme Court was creating a crime in the ruling, because now it's allowed to use anti-racism law to protect cases against homophobia until the parliament create a new law for these cases. The following two cases are related to political rights. There was two decisions on this matter. The first one decided that the mandate of the deputy, for example, doesn't belong to the person, to the congressman or congresswoman. it belongs to the party. So if a deputy changes his party during the mandate, if it's not a reasonable change, the congressman loses the mandate, and the mandate belongs to the party, so the party can call for a replacement of the person. Okay, this is called political party loyalty, trying to say that the congressman or the congresswoman must be member of the party that elected him. Okay, so if it's not the case, if he changed the party, the mandate belongs to the party. And the second one, related to political rights, is related to corporate campaign donations. During many years in Brazil, electoral campaigns were supported by corporations, better to say, corporations, private agents. They could afford, they could pay for electoral campaigns. This was a super debatable cases on how private agents could influence on the electoral campaigns. And in some years ago, the Brazilian Supreme Court decided to prohibit the use of corporate money in electoral campaigns. So now it is unconstitutional, the corporate financing in electoral campaigns. Just the public sector, just the people, the individual people can pay for they can donate for electoral campaign, and also there is a public fund to financing these campaigns as well. So, but it's forbidden for the corporations to spend money in electoral campaigns. The next case it was decided before the pandemic. It was a case on homeschooling, and the Supreme Court in Brazil said that the Constitution does not forbid homeschooling. However, we don't have an ordinary law regulating this situation. So until we have ordinary law regulating this homeschooling, we can't have homeschooling in Brazil. But the Supreme Court is stressed that the Brazilian Constitution doesn't forbid it. However, we don't have ordinary law regulating it. And this case was decided just before the pandemic. I don't know if people nowadays, mainly mothers and fathers of kids, they support this homeschooling because they are super tired of kids at home. But when the case was decided, there was a movement trying to support this homeschooling. But I don't know now how the things are going. The following case is concerned on social rights, mainly health rights. Professor Rubens said that the Brazilian Constitution has a long list of social rights, and this is real. We have in our article number 6, for example, a list of many social rights. The problem in Brazil, when when you are in a country with a huge social inequality and huge budgetary limits, the problem is how to give effectiveness for these rights, which depend on money, depend on budget. So the judicialization of social rights in Brazil is a strong issue, it's a permanent issue for the judiciary. So in this case, on high cost medicines, on high cost treatments, medical treatments, the Brazilian Supreme Court decided that there is a duty of the state to supply high cost medicines for those who cannot afford it. However, this obligation does not encompass experimental drugs, drugs that are still under experimental process. They are not allowed to be paid for by the state. The state doesn't have this obligation. This is important to say because when the judicialization of social rights started in Brazil, people used the judicial review, the judiciary, to claim for different high-cost medicines. Some people find a experimental drug in Thailand, for example, for this case. They claimed for this, the payment for this medicine in the Brazilian judiciary. So, oh, I have a very special disease. There is an experimental drug under development in Russia, for example. So I need this treatment for my individual disease. This was super common in the suits, in the cases under the Brazilian judiciary. But the Supreme Court said, wait, there is the duty of the state to pay for it, but there is no obligation, there is no right for experimental drugs. The drugs must be accepted by the federal organ for the health system in Brazil. First, this institution called Anvisa, it's an agency in the federal level, which has the responsibility to include in a list what are the drugs that the state will pay for the Brazilian people. So if the treatment or the drug is in this list, there is the responsibility, the obligation for the state to pay for the individual cases, okay? The last two cases are related to the prison system in Brazil. They are about criminal law. The first case was super debated because was related to Lula prison, the prison of the former president in Brazil. It's the case on presumption of innocence. It's a long story. I'm not going to tell the details. But the last decision of the Supreme Court in Brazil, the Brazilian Supreme Court changed a lot in this case, but the last decision of the Supreme Court said that it is unconstitutional to start the criminal conviction to jail before all the appeals be ruled. And this is important because in Brazil, in our criminal procedure, we have many appeals. We have appeals from for the second level of judiciary, for the third level of the judiciary, and in some cases, you can bring the case, the criminal case, to the Supreme Court. So the Supreme Court in Brazil has many cases to decide, and sometimes these cases they last many times to be decided, and many times this is a problem in terms of preclusion, in terms of deadlines. But our Supreme Court decided it's not allowed to start the criminal conviction before all the appeals, and the appeals of the Supreme Court as well. Okay, just with the res judicata, the conviction to jail can start. This is a ruling supporting the constitutional right of presumption of innocence. Everyone is innocent until all the appeals are ruled. Okay. And the last case, it's a case still pending in our Supreme Court. We just have a precautionary measure in this case. In this case, it's not totally decided. It corresponds to an importation of institution from Colombia, which is the institution of unconstitutional state of affairs. This institution, to sum up, says that there is a massive violation of human rights in one specific situation. In Brazil, the use of this unconstitutional state of affairs was decided upon the Brazilian prison system. So this Brazilian Supreme Court said that our prison system in Brazil is under an unconstitutional state of affairs because there is a huge violation of human rights in every single prison in Brazil. So it is a statement. The Brazilian Supreme Court said, here in Brazil, the Brazilian prison system is causing a massive violation of human rights. In practice, this decision is under development. The first measures taken soon after this decision was trying to change the budget of the Brazilian prison system. So the Supreme Court sent some orders to the executive branch to create more or better conditions for the prisoners in Brazil, trying to change the way the budget is spread, is divided between all the states. This is a pending case, but it's an important case representing this importation of this institution of unconstitutional state of affairs. Okay, so I tried to give you a panorama of the cases in Brazil, trying to show you how the Brazilian Supreme Court treats human rights when they have to decide on them. Now, to finish my presentation, there is an article in our book as well, trying to highlight some challenges of the Brazilian Supreme Court as a human rights guardians. What are the challenges of the Brazilian Supreme Court as a human rights guardian? Because when you look at these cases, we can conclude that the Brazilian Supreme Court has a positive engagement in human rights, and this is true. This is true in our Supreme Court. However, as we are constitutionalists and we are studying the Brazilian Supreme Court, we are trying as well to focus on institutional problems, on what are the drawbacks or what are the advantages, what are the problems in terms of the Supreme Court, in terms of the institution, the Brazilian institution. And here, the paper that focused on this issue in the book tried to highlight the following institutional problems of our Supreme Court. These are 4 examples of institutional problems. The first one is the overlapping competences. The Brazilian Supreme Court, we say Supreme Court, but the Brazilian Supreme Court has 3 main competences. It is a Supreme Court as a court of appeals. You can bring one case to the Brazilian Supreme Court if there is a constitutional discussion in our case. So a single prison could be achieved the Supreme Court. This is one competence. The second competence is a competence as a constitutional court. We have in Brazil the Kelsenian model of judicial review and the US model of judicial review. We have these 2 models of judicial review, a single case and an abstract case for the judicial review. So we have this additional competence. The Brazilian Supreme Court can issue on constitutional law in a single case and in a general case, in abstract case, okay? And the second and the third competence is the competence in investigating, in deciding on criminal competences in criminal cases of high authorities. Authorities like deputies, senators, the president of the republic. Criminal cases against these people, they are processed, they are decided by the Brazilian Supreme Court. So the Brazilian Supreme Court has this additional criminal competence. And as you may know, in the last years, the deputies, the senators, and the former presidents are under super criminal investigations in Brazil. So there was a high number of these cases in our Supreme Court. So the result of these overlapping competences is a huge number of cases to be decided. The Brazilian Supreme Court is one of the Supreme Court that has the most number of cases to decide. And this is a problem when we have in mind the fact that the Supreme Court must dedicate your time for constitutional cases, for super important cases like the cases I have mentioned before. If there is so many cases to be decided, there's no time enough to think, to deliberate, to discuss constitutional important issues like the cases before. Okay, so this is the first institutional problem of our Supreme Court. The second and the third feature of these problems are they are both related to each other. As I said, the Brazilian Supreme Court is composed of 11 justices. The decisions taken by these judges, they are collegiate decisions. They are decisions of one single institution, the Brazilian Supreme Court. In Brazil, the STF decides by seriating a process, which corresponds to some to add the 11 opinions. So we have the opinion of one justice and we have the opinion of the second justice, and they decide by majority. Okay? They decide by majority. 6 against 5 and so on. So this is the way how the main cases in Brazilian Supreme Court are decided by the majority. We just count hands, count opinions, count the votes of the justices. However, there is in recent years a strong use of individual decisions in our Supreme Courts. Decisions taken by one single justice. This is super controversial because they use this power to rule individually, to create sometimes an individual agenda. What I'm saying about an individual agenda, justices in the Supreme Court in Brazil, they have the power to decide when they decide. What does it mean? They can use time, postponement of time, delays, to decide when they are going to offer their opinions. So this is quite difficult to understand, mainly when this court leads with super important political cases. And sometimes they are fast in their decision. Sometimes they postpone their decisions, and we don't have any form of stability or any form of previsibility to understand when they are going to decide the cases. And this is a huge problem, okay? And the last one is a problem quite particular in Brazil, which is the overexposure to media. In Brazil, the justice, they are celebrities. They are super famous. People know, people from your aunt, your grandma, your aunt, they know the names of the justice. They support one or another justice. Justices in Brazil are every single day giving interviews. They are appearing in TV shows. They are almost in, they're still not in reality shows, but I cannot say that they will not be, because they are super famous. Their egos are super exposed in the social media. They have Twitters, they have Instagrams, the decisions of our Supreme Court is broadcasted in a TV. There is the TV Justice. It's an institutional channel in Brazil, and this overexposure to media, it can help people to be more close to the Supreme Court. However, this feature, this characteristic of our justices sometimes could lead to absence of impartiality. We know the friends, we know who are they meeting, we know who are with who they are talking with, we know their meetings, their agendas, we know their papers, we know their interviews. So in terms of impartiality of the judiciary, I believe that the impartiality of the Supreme Court is going to be threatened by this over social media. Okay, so these are the institutional problems of this Supreme Court, who has super important decisions on human rights. So this is important to present because with this information, we don't have one single face of the Supreme Court, just the beautiful face of the beautiful cases. We have this Janus face, we can say, the face of the good decision, but the face of the institutional problems. So sorry for the time. I have used the time too long, but this was a great opportunity to present you the Brazilian Supreme Court, the cases, and the Brazilian constitutional law. Thank you for the attention, and we welcome questions, comments that you may have. Thank you so much, Georgie.
Thank you very much,
Okay,
Rubens.
may I say
Thank
something
you, Jairo,
else?
for the presentation. Very, very interesting. Let me stop now the share.
Jorge, may I say
I'm going to
anything?
stop the recording, and then we can start with questions and answers. Before we finish, Rubens, do you want to say anything before I stop the recording?
Yeah.
Yes.
Are you listening to me? Yeah. Okay.
Yeah, we are still
Okay.
recording. Yes.
Okay. Jorge, thank you. Jairo, congratulations. Brilliant as even. I would like to say some highlights. The first of it is we selected just a few cases. I mentioned, and Jairo said, some leading cases for the book, because we have limitations in the editor's process. But we have a work in progress, and the promises, I don't know with the pandemic, but by Lexington to make another sequences with another important leading cases. And why to say that? Because we have, as Jairo said, and I before, Supremo Tribunal Federal, a Supreme Court, leading all the decisions in everything in Brazil. That's for one side. It's important because, as we said in the book, in the presentations, we have to put the Constitution into effect. I mean, in the human rights field. As I mentioned before, they are extensive human rights, and they are taken to be universal. So, if the powers, I mean, legislative, executive, didn't make their efforts to put the human rights into reality, judicial system, especially tribunals, especially the Supreme Court, are doing their role. That's perfect. But in the other side, I would say this process deepened in about 2007. It put, as Jairo mentioned, Supremo Tribunal Federal in our lives every day. And there is a perception and a deep debate in Brazil by now that for the reasons we've presented, Supremo Tribunal Federal is deciding everything and doing, as to say, previous moral decisions in everything in Brazil right now. That's something that we couldn't agree. One thing is, given the rights, their position in the Constitution system, not the literally text of the Constitution, but what was in the mind of the pact I mentioned before, the National Pact to have a democratic state in Brazil. But the other thing is what Supremo Tribunal Federal is doing in fields like electoral one and decisions in affecting all the levels of administration in Brazil. I would mention leftist presidencies, as for instance, Lula da Silva, Dilma Rousseff, or the other field, as Bolsonaro by now. But the problem is, there are days when we think, do we have a constitution, or just we have a divine tribunal that is saying where Brazil should go? That's a problem, because we are constitutionalists. So constitution is the pact that a country makes when it's necessary, not a revolution by with blood, but a revolution in everything. And that's the root where we have to act. And Supremo Tribunal Federal is exciting. It's, let's see what happened yesterday. Just one of the several examples I could show you, I could tell you, sorry. In a televised judgment, there was a moment that the brand new Justice Cássio gave the possibility of the former judge that conducted the car wash investigation, Moro, that later became the justice ministers also, was not suspect. And there was another part of the day, by night in Brazil, another justice, Carmen Lúcia, that had judged before 2 years ago, because the judgment took almost 2 years, changed her vote and put into effect by a majority of 3-2 that Moro is suspect. So it nullified everything in the condemnation of several people, including Lula da Silva. So yesterday, what you saw in Brazil, you saw a changement from day to night, or tonight today, in the electoral panorama for the presidential elections next year. So Supremo Tribunal Federal has by now a powerful, I would say it's something like mythological gods in Greece, in the mythological sayings, because they are doing everything in almost, I would say, every field. So the debate by now, should we stay in that state of mind, or should we give again or think again in giving the legislative and executive the powers that they used to have? That's a problem, because I'm not saying we shouldn't take judicial review as a way to putting human rights into effect, but just to think about the power the Supremo Tribunal Federal got it in the recent years, and to idealize a future more democratic with so less, I would say, previous morals judgments. That's just a highlight in the brilliant presentation made by Jairo. And if you, that's all. I remember the guy from she is in Poland by now, that asked us about justice. But if you,
yeah, I'll stop the recording. Because I mean, for the audience, I'll have to stop the recording now, to allow questions and answers, for privacy. We deal with many jurisdictions, so I have to ask permission, to be recording. But before I stop the recording, thanks, obrigado, Rubens and Jairo. Dr. Beisa and Dr. Lima. A very interesting presentation, very informative. I'm conscious it took longer than usual because we had the same last time. It's a book presentation, not a paper. So thank you very much for both your efforts. And I wanted to say before I stop the recording, very interesting because it's not only informative, but we have, black letter law, constitutional law, and philosophy. We talk about values. And it's been probably one of the most controversial presentations we had so far in these 6 years, with Juris North. And very briefly, because I'll open for the discussion. We talk about, positive and negative values, impartiality versus partiality. And then we talk about things like no campaign donations and transparency. But then we know in reality in Brazil, and many Latin American countries and around the world, corruption, Iglesia Universal, supporting the government and the elections. So it didn't make sense to me. And now it's spreading to other countries in Latin America, Iglesia Universal. Then we talk about abortion, and I'm thinking about self-ownership, the fetus and the mom, and same discussion we had in many countries, including Mexico and Argentina recently. Gay marriage. It's funny because I've seen law change in Latin America about this before the UK. We had constitutions and national law in Argentina, Mexico, before the UK. So again, how beautiful it is to see the evolution in Latin America before Europe, because it seems, we are always behind, but in many of these issues we start discussing, we are, at the front, like indigenous rights. And many others, we have now Dr. Clarice Duarte from Brazil with us today. She may ask, about poverty. When you talk about social rights, and the idea about expensive medication, or high price medication, and reality is, yes, the rights are there. Then I have to ask myself, do people really have access to them? So thank you very much again, very informative, but at the same time, very controversial presentation. So once again, obrigado, Jairo and Rubens. And I'm going to stop the recording, so to allow the questions and answers. Let me stop here.